Any mention?
Wait, please, Lordship. Your Lordship, I beg to mention item number 11 of today's. I prefer 2 weeks' time, Your Lordship.
The other side? Yes.
We have no objection, Lordship.
Yes, 11. At the request of the petitioner, list after 2 weeks. Yes.
Much obliged.
Yes, Mr. Lordship.
Lordship, item 6 and 7. Those cantonment cases, cantonment matters which are still under consideration right now.
How long shall we keep it pending?
So what we understand is under active consideration. If it's
That is-
allowed, we'll be entitled to a lot of relief.
Probably right from the time this bench started taking up this matter.
Absolutely, Your Lordship.
So that is what. Yes, you are the authority, you can say something.
In fact, what it says, that is the instruction I have, is with drawing with army, because not only our cantonment, there are all 52 cantonments all over the country. They are doing their
So after 3 weeks.
3 weeks or 4 weeks, Lordship.
3 weeks is
3 weeks.
at the joint request of the parties, list after 3 weeks. 6 and 7. 6 and 7.
6 and 7.
Value.
Obliged. Obliged.
May I please, Lordship? Lordship, I beg to move a mention memo for listing of a matter today, if possible. Lordship, this is an offshoot of the last time that order of Moonshine Nongkra, Lordship, regarding the POXO at Nongpo, where the cross-examination was denied, and Lordship had passed an order to recall the witnesses for cross-examination. Again, an order has been passed, Lordship. Again, in this order, a direction has been given that no VC will be allowed for any evidence. No reason has been assigned. We have no difficulty in going down personally, but kindly.
Why don't you go personally if you
No,
do
no,
not have
we have no
difficulty?
difficulty in, but this kind of, because Lordship, this will become a
If you are
precedent
coming it for your just moral satisfaction, then there
no,
is
no,
no use.
not I'm not coming for moral
And
satisfaction.
If that be the thing, then you have to. Do you have the all those regulations guiding that BC things,
Lordship, even
which
the
makes it compulsory?
our High Court also has the rules. Lordship, we have
you are
filed.
holding it.
We have filed the petition, Lordship.
You have yet to see with the petition.
It's
All the details are there.
Lordship, yes. The details are there, the rules and the Supreme Court judgments.
Yes,
And
Mr. Khan.
You want to mention
today or tomorrow also is fine, Lordship.
Let's see, we just got the petition just now, Lordship. Unless we don't.
We'll have it tomorrow.
Tomorrow, Lordship. Tomorrow.
Your Lordship, I'd like to mention item 12, Your Lordship. Joint request, Your Lordship, after 2 weeks.
Yes.
It's a joint request, Your Lordship.
It's a joint request.
Yes, Your Lordship.
When do you want it?
After 2 weeks, Your Lordship.
12 at the joint request of the parties, list after 2 weeks. Yes.
Your Lordship, similar prayer for item 13, Your Lordship. I have taken the consent of the.
That is not a joint request.
No.
No. Yes. You are also there, Mr.
No, he's assisting me.
Yes, 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 at the request of the petitioner, this is not after 2 weeks. Yes.
Highly obliged.
Please, Lordship. Lordship, the joint request, Your Lordship, item number 9. So, Your Lordship,
Yes.
if this matter may be taken up after 3 weeks, Your Lordship.
I go 1 to 3 matters.
4.
3 weeks at the joint request of the parties, item 9. Yes.
Much obliged, Lordship.
Highly obliged.
Joint request of 4 and the petitioner matter. Joint request of the
Respondent 4
petitioner
and,
number 4 and the
and the
petitioner.
petition.
So you have objection?
Matter, there was some urgency. Why? Because their benefits, service benefits have been denied and it was delayed. And senior counsel is not here. I can't.
This name. This is
Highly obliged.
yes.
Daily cause list, item number 1.
Yes.
May it please, Your Lordship.
Yes.
Lordship, we have received the paper book in this matter. I pray that the matter may be posted for hearing after 3 weeks, Lordship.
Paperwork has been prepared. Yes.
Paper book was read, yes, Your
You have
Lordship.
also received.
Yes, Lordship.
Yes.
Another thing, Your Lordship, whether lower court record has been remitted back to the High Court, Your Lordship, because it had been sent for acceptance of bail on the last date.
So
When
has
Your
it come
Lordship,
back?
whether it's come back, I don't know.
Anyway,
It has
records
come
so
back, then it's all right, Your Lordship.
Yes. The record has come back from the trial court. Eh? Oh yes, yes. Yes, the parties submit that the paper book in this matter has already been prepared and the matter is ready for hearing. In view of the submission, list this matter for hearing when?
After 3 weeks, Your Lordship.
After 3 weeks. Yes.
Lordship. Deeply obliged, Lordship.
Item number 3.
Yes.
Yes. Lordship, the respondents are yet to file the affidavit. Response 6 and 7.
Yes. Who is 5, 6, 7?
What's your government for filing?
Yes, that has been submitted. Only 5, 6, 7 it is required. Who has responded 5, 6, 7? Who is the present?
6 and 7
not filing, my lord.
This
Item number 5, you are not
5
filing.
is not filing.
No, in this item number 3, WPC 149,
No, WPC number 149.
we are not filing respondent number 5.
But then on the last occasion, I think submission was made that will be.
That was regarding to the next item, my lord. WPC 164.
So that has been wrongly.
Some misunderstanding on the last date.
Yes.
I appear for the private respondent 6 and 7.
Yes. When you will be filing your.
2 weeks time,
Okay. We just.
both the matters.
Okay. Just record it correctly. If submissions should go correctly. In which matter are these things? 149. This is already. It was written that respondent 5 was paid for time for grant of this thing. For allowing them to file a reply. And then now here the learned counsel submits that he has not made this submission. Anyway, just say at 149, WC 149. Mr. P. Nongri, learned counsel applying for the respondent number 6 and 7. Place for grant of further time for filing a counter affidavit in the matter. Before that, you just say Mr. Jirwa, W. Jirwa, learned counsel applying for the respondent number 5 submits that no affidavit, no counter affidavit is required to be filed. Or no counter affidavit will be filed on behalf of the state respondent. Then in the second line you say Mr. So and so, then ask for so and so, just say prayer alert, please for 2 weeks. Okay, you got it. The first line will be that thing, second line this and then this. 2 weeks, Mr.
Item number 4.
They are also same order.
We have filed.
Yes. Just as request, Mr. P. Nongri, learned counsel applying for the respondent number 6 and 7. Praise for and granted further 2 weeks time for filing counter affidavit.
Respondent number 5 already filed, my lord. Respondent number 5 you have already filed.
You have already filed.
Your Lordship,
Then and then you say
rejoined.
Mr. So and so, Mr. Renja submits that the affidavit of opposition on behalf of the respondent number 5 has already been filed.
I'll need to file rejoined, Your Lordship, on the affidavit filed by respondent number 5.
And do not give us line. Just change it. Just write it. Rewrite the order. It says Mr. W. Jirwa, learned counsel applying for the respondent number 5 submits that a counter affidavit on behalf of the state respondent has already been filed. Mr. P. Nongri, learned counsel applying for the respondent number 6 and 7, please for grant of for the time for filing a counter affidavit. Learned counsel for the petitioner, Mr. Kriya. Yes. Mr. V. Keriam, Lord Counsel for the petitioner, prays for Mr. Petitioner also prays for grant of time for filing and rejoinder against the original petition filed by the respondent. Yes. Then next is a prayer reload. Just after 2 weeks.
Much obliged.
Obliged, my lord.
Hearing item number 5.
Yes. What is this?
Your Lordship, this is a long pending matter now for over 8 years now, which has been pending for
Yes,
years.
you are appealing for the petitioner.
Your Lordship, I am for the applicant. What has happened here, Your Lordship? On 16/7/2018, the matter was, they proceeded ex parte against me. This was pointed out at the time when the matter was heard. It was pointed out by the writ petitioner that
Yes, later on, the later stage.
at a very belated stage.
Though thereafter it took part. Yes. Now you have filed an application for setting
I
aside.
filed this for setting aside, Your
Yes.
Lordship.
Any objection?
My lord,
Yes.
it's difficult out here, my lord, to object also. It's difficult to object also.
You should
Your lordship
not,
will
normal course you should not.
Normally I would not. Normally I would not have, my lord. But in this matter, my lord, see, your lordship will appreciate the fact that the applicant himself states that in para 6,
Yes.
that it is us who brought to his notice of the existence of an order, my lord. An order of this court, my lord. All the while he had been appearing, my lord. And it seems that the applicant here expects that all orders that have fallen from this court must be put to his notice by other parties, my lord, not by himself. He's not bound by the orders of this court.
But anyway, what is the reasons of his non-appearance given on that day?
My lord, I don't see any reasons, my lord. But what is surprising and what is even more embarrassing, my lord,
What law requires in such a case when expert order is?
my lord, a reason, my lord, a reason.
Yes, they must
At
satisfy
least
the court.
a reason, my lord, to satisfy this court that yes, we were either wrong or we were not in a position to come before this court at the earlier stage. That should have been done, my lord. But as I said, my lord, what is even more embarrassing, my lord, for me standing at the bar here, my lord, is that a senior advocate, my lord, has been made a scapegoat in this one, my lord. Number one. Another is, my lord, is that a presiding officer, a now presiding officer of another court, my lord, lower court, my lord, is now being put to notice before this court that she is also one of the erring advocates then, my lord. And my lord will also appreciate if your lordship, if your lordship, if I may,
Why you are raising all those unpleasant?
no, it is unpleasant. I did not raise it, my lord. If your lordship uses the application, my lord.
That is all right. Just tell us what is the reason here. We are more concerned with that.
I'm not here with the reason, my lord. They are, my lord. I'm just here telling this court
Yes,
what reason they have brought.
That, Your Lordship, when the matter proceeded ex parte, there was a communication gap. Because the matter has been pending for a long time.
Where you have stated that on particular day for what reason? On what date it was ordered to proceed ex parte? What is the date of the order?
Ex parte order was 16th of July 2018, my lord.
16th of July
2018, my lord. That is 2018.
Is there any delay in preparing this application?
I think he'll be in a better position, my lord.
After this order was passed ex parte, even then I appeared before this court on every subsequent date.
So what is the consequence of that? Or will the consequence of that? That means that order will become inoperative.
No, I'm not saying that, Your Lordship, but to establish my bona fide, Your Lord. Well, normal circumstances, I leave it to the discretion of this court.
See, normally
And Your Lordship,
this kind of petitions, the court should be generous.
Lordship.
But then the problem is that at least we should fulfill the requirement of law. There has to be some averment with regard to your non-appearance on that particular day. Show us on which day and what prohibited.
No, Your Lordship, it's not that non-appearance. They appeared. Kindly read the order, Your Lordship.
Yes, what is the order?
Annexure 1, Your Lordship.
Yes.
Annexure 1.
Yes.
Then the counsel for respondent number 4 submit that she has lost contact with the client. Respondent number 4. Therefore has no instructions. That being so, respondent number 4 is set in ex parte.
So now once a counsel loses his contact with his client, How could he continue to appear in this matter? Huh? And then the
That-
council,
that is why-
and council says he doesn't have the knowledge of passing of this order. How can it be possible?
Absolutely, Your Lordship, because there was a communication gap, Your Lordship. That is only my
No,
reason.
but
Your
then
Lordship.
how come Mr. Thank you has pointed out
My lord.
just now that it was he who brought it to your knowledge that there is expert in that. But then it appears
No, Your Lordship. Can you read paragraphs 7 and 8, Your Lordship, for my application?
Prior to that, if I may, my lord.
paragraph 6. What is the meaning of paragraph 6?
Your Lordship.
Page 3, paragraph 6 of your application.
The applicant states that on 22/3/2024, the counsel for the opposite party, number 1, the petitioner, has brought to the notice of this court that by order dated 16/7/2018, the matter has proceeded ex parte against the applicant, number 4.
That is the reason. my lord.
Which way you take this?
So, Your Lordship, my
You
humble...
want to say that 16.7 order was not in your knowledge?
Absolutely, Your Lordship, because we did not run through the entire order sheets. We under the
But then
impression...
appreciate the fact on 16.7 the order was passed on the basis of your submission. You said that you have lost contact with your client.
No, Your Lordship, it's the earlier counsel who had appeared.
Which way
My
does
lord.
it make a matter? It is
Because, Your Lordship, they were handling the brief at that point of time, Your Lordship.
So earlier counsel, when earlier counsel had given up, once you entered, you did not bother to check the record. Yes.
My humble submission,
My lord.
everything was
My lord,
modified,
if I
Your
may,
Lordship.
if I may, my lord.
And I leave it to the discretion. Your Lordship will have to go to the merits also because I've not filed my affidavit, but I'm relying only on the order passed by the
That is
CM, 8
misguiding
years,
this
Your
court, my
Your
lord.
Lordship, can you see the conduct of the other side also? 8
My
years
lord.
has been pending now, Your Lordship. Repeatedly, they've been seeking for time.
We hear on the application for
They also
condemnation
did
of
not
duty.
matter been heard.
Did not point out your subsequent appearance. They also did not point out. They do not.
No.
Yes. There's a fault on your part. You
Right, my
cannot
lord, because
make
I
it-
should have informed him of the order of this court, which also binds him. my lord.
See, there is no question of informing.
Duty bound that.
Even after the passing of that ex parte proceeding order, if they had taken part, that was your duty to point it out.
My
You
lord.
should have objected to it. You did not object. There's nothing on record to show that you have ever raised any objection.
No, my lord. See, my lord, as far as I'm concerned, my lord, the orders of this court bind both me and him, my lord. It's not that it's one-sided, my lord. And it's not my duty, my lord, to inform him of any order that goes against him, my
It
lord.
means you would love to him continue. See, till it came to hearing on merits,
No, my lord.
you did not raise about their participation.
No, when it came on the hearing, my lord, it was I who pointed out to him that he's been set in ex parte.
Bhavan, before that, you see, you are admitting what the court is saying.
Right.
That is what you see. The question of the court is that if at all there was an order debarring them from appearing in this matter, or there is an order of ex parte proceedings there,
Right.
passed in 2018,
Right.
and if thereafter also they continued to appear in this matter,
Right.
how could you did not raise any objection?
There was never a hearing then, my lord. There was never a hearing then, my lord.
So it means you want to say there is a not hearing means even today also it is for hearing.
No,
Every
today
day
it's for hearing for this application, my
No,
lord.
no, even it is listed for orders. It's
Right,
for
right,
hearing.
right,
You
I
cannot
can
say
see,
it
I
is
can
no
see to
hearing.
that. I can see to
Once
that.
party appeared, it's for hearing.
I can see to that, my lord.
Then,
But not
then
to.
how do you say there is no hearing? And what do you mean by that? Until unless there was an hearing, you would not have raised this.
No, my lord, I was not under that, my lord. I'm not saying that, my lord. I'm not saying that. I was under the impression that the orders of this court bind both the parties, my lord. And any counsel who appears for any other person or any other client of his should and is duty bound to go through the entire brief and know about the contents of the brief, despite the fact that other counsels had been.
Yes, they definitely.
Right, my lord.
Their
And
conduct
if
is
he.
blameworthy conduct. This court is not saying not that thing.
Right,
But
my
at the
lord.
same
Now.
time, your conduct also is blameworthy.
Okay, my lord. But now, my lord, if this application is to be.
Will not go too hyper-technical on this.
No, I'm not saying that. I'm not saying that, my lord. My lord, I'm just.
End this and we'll hear the matter on merits.
And also, my lord, they had also stated earlier, it's recorded in the orders, that they will rely on the affidavits placed by the district council.
I'll rely. I have
They've
only
already
one
stated
point
that.
to point out, Your Lordship, at the time of hearing.
You have not filed your affidavit in the
No, they have not. Now they're saying that they have not filed, so hence they require to be.
I'll rely on
heard.
the affidavit I'll reiterate my submissions.
But your lordship will also appreciate this fact, not that there's no reason in this application, not absolutely none.
Just because puts you so many questions, you should not become angry. You should maintain your composure, isn't it?
Right.
The thing is that this is something very peculiar.
My lord, more peculiar is, if I may direct
What
your,
is your objection?
if I may take your lordship, my lord, para 4, my lord, of the application.
Yes.
If your lordship has para 4.
Do you really have a serious objection, Mr.?
Yes, my lord. That is a serious allegation against somebody whom we hold in high esteem, my lord.
Yes. What is paragraph 4?
That the applicant states that the applicant has engaged the chamber of so and so and so, being a resident from remote village and so and so. As such, the applicant had solely relied upon the council for taking necessary steps in the aforesaid writ petition. That is an allegation, my lord, which means that the earlier council, my lord, was
It means the order passed.
right.
And this paragraph 4 doesn't go together. Order passed there, the court has recorded
Right.
that they have no objection.
Right.
Oh, sorry, no instruction.
Right.
And here there's something.
Right, man. And they're saying something very bad against somebody whom we hold in high repute.
Anyway, we'll just hear this matter on merits.
Right.
We'll just give them a chance.
I'm okay with that, man. But
Actually,
these
this
kinds
is
of allegations should not be there.
2018, after so many years, the application deserved rejection.
2000 days, man. 2000 plus days, man.
Normally, if it comes to civil proceeding, there is barred by limitation.
Obviously, man.
It's a writ petition, but then even then, principle of delay and lectures are clear. And hard Mr. P. Counsel preparing for the applicant, and also Mr. James Ruki. Managed counsel looking for. You are appearing for all the. No.
No, my lord. Mr. D is also there, man.
Opposite party number 1.
He is number 1.
He is opposite number 2, 3, and 4.
2, 3, and 4. And then Miss So and so. This one number, opposite party number 2, 3, and 4. Yes, what is your submission? Opposing, no objection. See, Mr. Thank you.
My lord.
Other respondent is not supporting your case.
No, they don't have to, my lord. In the main case, they're on the opposite side, my lord.
So that is the reason they are not.
Right, man.
Okay.
Herein comes the classic example of that ignorantia factor, excused ignorantia juris non excused, actually. My lord.
Remember those.
Right.
Maxims very well. Yes, then next program. This is an application for recalling order date restriction 7/2018 passed by this court, whereby it was ordered, whereby an order of ex parte proceeding was made against the applicant hearing. The learned counsel was the applicant submitted that there was a communication gap between the applicant and his appointed lawyers. Who was representing him at that point of time when this order date 6/7/2018 was passed. Stopping further submits that even after the passing of the order, the new sets of lawyers appointed by the applicant had taken part in the proceeding of the case until 22/3/2024, when the counsel for the opposite party number 1 pointed out to the court about the existence of the same order. It is a submission of the learned counsel that the applicant had no intention to default
appearance before the court, and he is very much interested to pursue the case. Submits that the passing of the order dated 16/7/2018 was an outcome of communication gap, and the applicant had no and the situation was, the applicant, and the situation was beyond the control of the applicant. Stop. It is that the order dated 16/7/2018 be called the learned counsel praise. This is learned counsel praise that the order dated 16/7/2018 be called, and the applicant may be given a chance to take part in the hearing of the WPC member, in the hearing of the writ petition. Stop. Mr. Thank you. The learned counsel, I think the opposite party on the other hand has objected to the application and has pointed out to the blameworthy conduct of the applicant on the ground that the applicant should have been vigilant about the passing of the orders of this court. He also has pointed out to the amendments made at paragraph number 4 and 6 of the application and submitted that these amendments go to show the existence of blameworthy conduct of the applicant, and in such a situation the application deserves no consideration. Sit down.
Thank you.
Be seated. At that point of time, some other sets of other rules were going. A consideration of relevant efforts reveals that the applicant was represented the writ petition by a different set of counsels at that point of time, and the order dated 16/7/2018 was passed on the basis of the submission made on behalf of the applicant at that point of time, that the counsel had lost contact with the applicant. However, a further perusal of the subsequent orders in the case of the writ petition revealed that the applicant was all along present in all subsequent dates, and his presence was recorded in all the orders. The opposite have to prevail. That though the applicant might have lost contact with his lawyer at certain point of time, but thereafter had not defaulted in appearance, and had shown his keen interest to contest the matter. Taking into consideration the interest of the applicant to contest the matter and for the ends of justice, it is deemed appropriate to recall the order dated 16/7/2018 accordingly. The order dated as 16/7/2018 is hereby recalled, and the applicant is allowed to take part. The remaining taking part in the proceeding of the writ petition number. In the writ petition number, we give C 412 the application stands allowed. Should not have much grievance.
Not that.
Then what about the writ petition? Ready for hearing?
Ready.
Start, let us then proceed. New proceeding, ready for hearing?
I am ready, my lord, but I've just been informed there's death in the family, my lord.
When do you want it?
Lord,
Now, it seems that you have not filed an affidavit.
no, my lord. And they've relied on they've chosen to.
I'll rely on the impugn order.
Okay, you are not going to file. Then we will record it.
Your Lordship.
With the writ petition. Part Learned Counsel of the parties. Mr. P. Nangvi, Learned Counsel appearing for the respondent number 4.
4, my lord.
Submits that no counter affidavit will be filed on behalf of the said respondent. Then others you have filed?
They have filed.
Yeah, filed. So it's otherwise thing.
Otherwise, pleadings are complete, my lord.
In view of the submission, address this matter after 2 weeks for hearing.
Obliged.
Much obliged, my lord.
Item number A.
Yes.
Please, Lordship. Your Lordship, in this matter, I am prepared to withdraw, Your Lordship.
Want to withdraw?
Yes, Your Lordship.
Okay. Miss so and so, Learned Counsel appearing for the record her name, huh? Petitioner on instruction submits that the petitioner does not want to press this application. And please for withdrawal of this. Stop. In view of the submission, comma, the writ petition stands dismissed on withdrawal.
Obliged.
Item number 10.
Yes. Please send it to me. Yes, Mr. Ahmed.
Lordship, in this matter, Lordship, apart from the evidence of the PW's, Lordship, the court had also taken the evidence of CW, court witness. Court witness.
Yes.
So, Lordship, I have got the orders, but only one copy. So, Lordship, I have to make some more copy for your Lordship's perusal. So, can you grant me at least 1 week time, Lordship?
My lord, 1 week time, I got this national moot court coming up. So after 2 weeks.
Lordship, 2 weeks.
Just as a joint request of the parties, let's just matter after 2 weeks.
Oh, yes,
In the meanwhile, we are not passing any order. Just give him
yes.
the copies of the things.
Yes, yes, Lordship.
You have to supply him also, no?
Yes, yes, Lordship. I'll supply.
Nothing more.